1971 graduate of Central Lafourche and a 1975 graduate of LSU. He finished his law degree at LSU in 1978, served as an attorney for a number of years, but then was a district court judge for Lafourche Parish from 1994 until his retirement in 2014. Since then, he still serves on an ad hoc basis as a judge in the area. We also have Mark Plaisance, who's a 1983 Nicholls Communication Arts graduate, which is now mass communication, but those days was communication arts. He served as a judge in Baker. But more recently, he argued successfully the case of Montgomery versus Louisiana before the United States Supreme Court in fall 2015. He served as a chief public defender for Lafourche Parish since spring 2015.
Correct.
Okay, we have Dr. Rusty Thysell, who is a member of the government department. He's a professor. He served on a number of these panels for us in the past and helps us each year on our mock appeals that we do within the department. We have Dr. Linda Martin, an assistant professor of mass communication, who's been on, this is her second year on the faculty here. And Ms. Nicki Boudreaux, who's an instructor of mass communication. She's worked with student media for a number of years and has been very active in the College Media Advisors, which is a national organization that's interested in free speech rights and press rights for students. So what we're going to do today is we're going to start this off and let each of our panelists speak for a few minutes on a couple of different topics, and then we hope to have some time at the end to open that up for questions. And kind of the idea here was that Dr. Thysell is going to talk about the 14th Amendment and its relationship to the Bill of Rights on state actions. Judge Simpson is going to talk in general about how Louisiana statutes and actions play into that. Ms. Plaisance is going to talk about, when we think about speech, we don't always necessarily think about how do we get access to the information we need to talk about. So he's going to talk about some access laws. Ms. Boudreaux is going to talk about free speech on college campuses, and Dr. Martin is going to talk about libel laws that can sometimes be used to repress speech.
Who do you want to go first?
Rusty, if you would, kind of give the context for the whole discussion.
Okay, hello. First of all, I'm Dr. Rusty Thysell. Okay, I'm going to give kind of a few introductory comments about the Bill of Rights. So you all know, hopefully, that we're talking about the First Amendment of the Bill of Rights, or the first 10 amendments. Let me emphasize right off the bat that when the original Constitution was written, it only applied to the national government. That's why that if you look at the First Amendment, it says Congress shall pass no law. There's no accident to that, was that it originally applied to the national government. It wasn't until the early part of the 20th century in Nicholls versus New York that the First Amendment was start applying to the states. And I want everybody to remember is that the Supreme Court used a vehicle, what is known as selective incorporation. And that's when they take a case by issue on a case-by-case basis, the Bill of Rights, and then they ask the question, is this right fundamental to a free society? And beginning in the early part of the 20th century in Nicholls, the court on a case-by-case basis started applying it to the states through the Due Process Clause. And again, it's just something that every law school student has to remember. And I want to emphasize that if you look at every one of the guarantees, I believe the only ones that aren't applied is excessive bail and fine and grand jury. I could be wrong, but I believe those are the only ones that apply. So again, just remember, okay, as to the First Amendment, the way I always explain it is speech is not an absolute. Even though the Constitution says Congress shall pass no law, speech is not an absolute in a democratic society. It's a conditional. In fact, if you look at all the Bill of Rights, even though it's written in absolute terms, the Bill of Rights is a very conditional thing. In fact, all the Bill of Rights is conditional. It's all based ultimately on interpretation. Okay, what are the kinds of speech? I just want to briefly talk about them. The way the Supreme Court is laid down is, and the ones I always learned is, first of all, you've got verbal speech, with the verbal and written speech, which you could argue is really what the Constitution was written for. But in the 20th century and beginning in the 1960s, they started talking about symbolic speech. conduct speech. And probably my favorite case is the case of Cohen versus California. You know, I won't use the words, but that's probably established the ideal of symbolic speech. And since that time, the court has laid down a whole series of symbolic speech. But I want to emphasize, people, everything is conditional. I mean, it's all based on judicial interpretation. You know, you can do such things as you can burn your, you can't burn your draft card, but you can burn the American flag. You can wear a Nazi armband. You can wear a black armband. You can do certain things. So the Constitution does say on the issue of conduct, you may exercise your constitutional rights, but everything is on a conditional basis. There's no absolutes. I also want to mention that in terms of absoluteness is that even though the Constitution says Congress shall pass no law, the courts have laid down certain exceptions. The issue of national security, the issue of libel, slander, and also the issue of obscenity. But if the problem is, it's like anything else, is how you define those words. How do you define obscenity? How do you define pornography? You know, we don't think about it in the year 2001, but at one time, obscenity issues was a very, very important issue. So again, that's what I just want to mention on the issue of speech. And again, that's the issue of free speech. I'll go to the next speaker.
Okay. Judge Simpson, if you want to talk about Louisiana law.
First of all, thanks for letting me speak with you today. Also, I'm kind of fighting an allergy, so please excuse my voice. I was asked to speak about restrictions that are permitted to be placed on free speech by government. And when I thought about doing this, I thought that maybe the best way to do it would be by example. So I'm going to first just generally read to you what the law is on this subject. And then I'm going to go through at least one scenario. I'm told I only have 5 minutes, so I think I'll only be able to get through one scenario with you on how these restrictions could affect free speech. The law that I'm going to read to you in just a minute has been developed primarily by federal courts. And this is generally the rule of law. Speech may be subject to regulations of the time, place, and manner of expression, which are content neutral. And what they mean by content neutral is the government's not trying to influence or change what you're saying. Also, the restriction must be narrowly tailored to serve a significant governmental interest, and it must leave open ample alternative channels of communication. So those are the 3 factors that if a case were to appear in a court, that a judge would be considering whether or not it's a reasonable restriction on free speech. Again, is it neutral? Is the content neutral? Is it narrowly tailored to serve a significant government interest? And does it leave open ample alternative channels of communication? The first scenario that I thought I would address is something that was on the news today. There's some demonstrations, some protests going on in St. Louis. When I was young, we called them demonstrations. I think now they refer to them as protests or marches. And obviously this is a form of free speech. It's a way for people to express, usually in a group together, their beliefs on a certain subject. Government is allowed, however, to place reasonable restrictions on protests or marches. And this scenario that I thought about, I was trying to think of a scenario that would be pretty bland, not to touch on anything that may cause someone to not feel pleasant about the scenario. Let's say that you're with a group of people and you support an increase in the minimum wage. You think that people aren't being paid enough. So your group gets together and you decide we're going to have a march to bring people's attention to this need. And you're aware that one of the areas in this state where there's the highest concentration of businesses is Poydras Street in New Orleans. Now, Poydras Street is a very busy street. As you know, the Superdome's there. They have all these corporate headquarters, all these high rises, hotels, the federal courts are there. So it's a very busy area. So if you make a decision, well, that's where we're going to have our demonstration, I can assure you that the city of New Orleans is going to have a little something to say about that. They are going to place some restrictions on what you do. As far as a restriction on time, obviously they're going to be concerned if you want to have your demonstration, your march, during the rush hour in the morning or rush hour in the afternoon. They're going to allow you to have your demonstration during a part of the day that causes the least disruption to the business activities that are going on Poitras Street. They're also going to, in all likelihood, place some restrictions on where you can have your demonstration. As I'm sure you know, Poitras Street is a very high traffic area. A lot of people moving on that street. So it's very unlikely that the city of New Orleans is going to allow you to march on the street itself or to block the street. Also, it's very unlikely that they can allow you to congregate around the entrance to any particular building because people have the right of access to and from these buildings. So those are the type of restrictions that most likely can be placed upon you if you want to demonstrate in favor of the minimum wage, raising the minimum wage on Poitras Street. They're going to be required, though, to accommodate you. They're not going to be able to say you can't have any demonstration at all. They'll put a limitation at the time you can do it and the location where you can do it. They'll probably set aside an area along the street where you can march, put up your placards, your signs, which will not interfere with the roadway and would not interfere with people's access to any of the buildings. And if someone protests, the decisions made by the city in restricting your right of free speech, the factors that I spoke about just a moment ago are the factors that they're going to look at. And basically, they're going to ask, was the restriction content neutral? Well, under the facts that I've just given, there was no effort by the city of New Orleans to in any way influence or prevent you or restrict you in any way from speaking, from saying what you want to say. So it'll pass muster on that. That's not a problem. On the issue of is it narrowly tailored to serve a significant government interest, I would argue that the city of New Orleans has a significant interest in the ability of the citizens of that city to be able to go to and from their work, and for the companies that operate in the city to be able to conduct their business operations. I don't think anybody would disagree that that is a significant governmental interest. And the question is, it has to be narrowly tailored. If they give you an area where you can protest, put up your signs, speak, then I feel that a court would find that that is narrowly tailored. And the last factor, it has to leave open ample alternative channels of communication. By giving you this other area where you can set up your signs, have your marches, I believe a court would find that they gave you ample alternative channels of communication. So in that scenario, I believe that the city of New Orleans would have acted with the authority to place reasonable restrictions on the time, place, and manner of your speech. Another scenario, and something people probably are not that aware of, is the state of Louisiana has placed many restrictions on your use of your cell phone, your computers, and other electronic devices. And a lot of those restrictions are actually contained within our criminal laws. And when I bring this up, I'm not suggesting that any of you would do any of these things that I'm about to allude to, okay? But this is a problem, I'm sure Mark would agree, that particularly in juvenile court, But even in adult criminal court, this is something that has really become cases that we see frequently. And I'm only going to talk about the two laws that we see most often. One is telephone harassment. And I'm not going to read the entire statute to you. I'm just going to give you the gist of it. And this is basically what it says. No person shall engage in a telephone call with another person and use obscene, profane, vulgar, or indecent language with the intent to coerce, intimidate, or harass another person. They have a statute called cyberstalking. Electronic mail or communication to another repeatedly, whether or not a conversation ensues, for the purpose of threatening or terrifying or harassing any person, that is also unlawful. And when you apply those earlier factors that we talked about to see whether or not this would pass constitutional muster, whether they would find that this is an unreasonable restriction on your ability to speak freely, I would argue that these statutes do not infringe unnecessarily on your rights of free speech. These statutes are content neutral. They don't say you can't discuss things with someone. You may be very angry with someone, you may disagree with someone on some personal or social or political issue. This doesn't prevent you from having some discourse with them, some discussion. What it does affect is the manner in which you speak with the person. Does it serve a significant government purpose? I would argue that it does, because I think the government has a very strong interest in whether or not citizens feel threatened by other citizens. That's what the criminal law system is all about. And the third factor is there ample alternative channels of communication. I believe it does leave ample alternative channels. You can discuss with people your feelings about any subject matter you want, as long as you don't engage in the activities which they have indicated would be unlawful. So if someone were to constitutionally challenge in court when I was sitting as a judge either one of these statutes, I believe I'd have reached the decision that these statutes are constitutional, that the restrictions they place do not unreasonably violate your right of free speech. I know I'm over my time. I'm sorry.
He knows how much I want to speak, so he'll cut into my time. So if you don't have the ability to have a deep throat, and for those of you who have read about all the president's men to get you information and documents, how do you go about finding out all of the dirt you want to find out, or the information you want to find out about a public body or a public entity? And how do you protect yourself when they tell you no? Louisiana, and I'll just quote it directly, the right of access to public records is guaranteed by the Louisiana Constitution. And because of that, the courts have said that any challenges to public records, if you're denied public records, must be construed liberally in your favor and against the entity that is trying to deny you the public record. There's two basic, we have public records and then we have public meetings. Let's start with the second one first. Generally speaking, all public bodies must meet in public. There are certain limitations under the law for them to go in what's called executive session. To do that, they have to publish that on their agenda, and if it involves a specific person, like an employee, they must advise that employee that they're thinking of going into executive session, because the employee has the right that whatever takes place in the public rather than in a closed session. In other words, if the parish council, who tends to be in the news more often than not lately, decide they want to go into a meeting to talk about a specific employee, or because maybe they feel the employee is doing something wrong, illegal, so forth and so on, and that employee says, I want y'all to discuss whatever I'm supposedly doing in public, on the TV, in front of the newspapers, the public body cannot override that person's desire to do so. generally speaking, a public body does go into executive session. One of the big ones that they can go into executive session is to discuss litigation. The theory in that is whenever you talk to your attorney, you have attorney-client privilege. The attorney cannot repeat what you in other words, if any one of you hire me or Judge Simpson, who now can practice as an attorney, and as soon as we have an agreement and you say, I killed someone, we can't repeat that to anyone. That's confidential. We're like your priests, okay? And trust me, some of the things I've heard as a lawyer would put a priest would cry. It's anyway. But the public body can go into executive session, discuss litigation, because if you try to negotiate the settlement of a case, you don't want to put in the newspaper that the Lafourche Parish Council gave their attorney permission to settle this case up to $50,000. Well, then the person sued is going to know right away, hey, you know what, I'm going to hold out because they only offered me 20, I can get 50. So there are certain exceptions to the public meetings. Public bodies tend to overdo closed doors or executive sessions. And the reason I use closed door is because when I was a student here and I worked part-time for the Daily Comment, and some of the public entities would meet so much in executive session that the publisher at the time, John Lynch, used to require us reporters to put in the lead paragraph, the so-and-so, the Lafourche Parish Council met in a he's wanted specific terms, closed door secret session, because it got so bad that these public entities were trying to avoid the public meetings law. So that's one, public meetings. You have a right to be there as a reporter, the public has a right to be there. If they want to throw you out, I'd cite them the law. Honestly, there was a meeting not that long ago of the State Public Defender Board, who I kind of answer to, that runs all the public defender programs in the state, and it's all lawyers. And one of them made a motion to go into executive session to discuss the interpretation of a legislative statute. And they threw us all out, and I said, guys, I'm not leaving. I said, it's a violation of the public meetings law for you to do that. And he said, well, we can do that and so forth. And even one person, who I'm not going to name, is a former judge sitting on the panel, and he said, of course you can do that. One Judge Simpson. No, somebody from north of the Mason-Dixon line, meaning north of Alexandria. And I said, look, I learned at Nicholls State University that you can't do this. And like 3 minutes later, they came get us all back and said, we decided that we cannot go into executive session to discuss the interpretation of a statute. I mean, that's just blatant wrong. Okay, so there are exceptions. The big one you may come across is, and I'm going to go real quick, is how do you get public records? Okay, you make a public records request to the entity. Okay, under Title 44 of the Code of Revised Statute, it sets forth all of the law regarding public records. You have a right to request any document that is used within the normal scope of government business. Okay? And if you request it in writing, you can actually request it orally at the counter, but if you request it within 72 hours, the public body must respond to you. Now, one thing I'm going to clarify. People think that you must be given the document itself within 72 hours. That is not necessarily correct. The public entity must respond to you because, for instance, what if it takes them time to dig it up? It's something from 6 years ago. It's in archives. They want you to find it. The issue becomes if they fail to respond to you within those 72 hours, then they're setting themselves up for penalties, attorney's fees, and damages that you may incur by having a file suit to do that. After 5 days, if you don't get it, you file suit, you can ask for an injunction. The judge will probably, more than likely you'll get it. I haven't seen many cases to where it's been denied. Then you set forth getting your damages, your attorney's fees, and then you get your documents. Now, understand this. The public body can require you to pay a reasonable copy fee which generally has been understood to be $1 a page. And if the request is overly burdensome and they can show that it requires hours and hours of research after hours, they can also require that you pay reasonable expense to gather the documents. But at the end of the day, you're entitled to the documents. If not, file a lawsuit. I haven't come across any cases where they've really denied the public records. And in most cases, it's very rare. Perhaps one that they may deny is, well, take that back. They did deny one. The newspaper in New Orleans filed suit against the Attorney General wanting documents related to the hospital in New Orleans that did not evacuate for Katrina. And there's an exception that says if the police, for lack of a better term generically, have not concluded an investigation, those documents are still confidential. The Attorney General convinced the court that since murder is imprescriptible and it could always bring a case against Dr. Paul, I believe her name was, that those documents could not be released, and the appellate court, the First Circuit, agreed that they could keep those documents hidden, at least for the foreseeable future.
Okay, so I'm going to take basically what these gentlemen have spoken about and bring it down to you on a college campus level. So just to put it into perspective, when you're 16, you get your driver's license, right? You can legally drive a car. When you're 18, you can register to vote. When you're 21, you are legally allowed to consume alcohol, right? All things that are typical milestones for college-age students. But the Supreme Court has actually not yet determined whether or not First Amendment rights apply to you as a college student in a majority of situations. So let me explain. In 1988, the Supreme Court decided a very important First Amendment case called Hazelwood Independent School District versus Kuhlmeyer. This was a high school case where a high school student newspaper was censored for a couple of articles that they had written. The advisor and the principal pulled those articles out of the paper, and the paper ran. When the students got to school, they saw their paper with blank spaces where those news articles would have been. That court made it all the way to, that case made it all the way to the Supreme Court. Supreme Court ruled that in many situations, high school teachers, administrators, and advisors have every right to censor high school student journalists. However, at the time, the Supreme Court decided that they were not going to determine whether or not those same rules applied to college students. Then in 2005, a court case called Hosty versus Carter was heard by the Seventh Circuit Court of Appeals. This was a censorship case at Governor State University, which is about 7,000 students, largely a commuter campus. Does that sound at all familiar to you guys? A lot like Nicholls. So it was basically a university just like ours. And the Seventh Circuit allowed or applied the Hazelwood ruling to a university newspaper, basically saying that in this instance, college students did not have any greater First Amendment protection as student journalists than their high school counterparts. They appealed this to the Supreme Court in 2006. The Supreme Court refused to hear it. So what does that mean for students at colleges and universities today? It means that for many student journalists and college students in general, when they are on their campuses, the First Amendment is in jeopardy. And we are seeing speech and press both censored on college campuses across the country actually at an alarming rate. I'll give you a few examples. Last week, a student journalist at the University of Texas in Austin was assaulted while covering a protest on campus. Also last week, student reporters were kicked out of an open student government meeting at North Carolina State University. The student newspaper at the University of Kentucky has been in a very long-lasting legal battle with administrators for denying access to public records. A student journalist at the University of Wisconsin at Oshkosh is fighting to obtain what they believe under their state statutes should be considered open records in an investigation of a removed university professor. A federal district judge in South Dakota ruled that public universities can actually discontinue funding of student media for any reason, even if those reasons are tied to content and opinions expressed by student journalists. And all of these examples I'm giving you took place within the last month. Even here at Nicholls, student journalists have had to deal with some similar issues regarding access to meetings, access to information, and denied public records requests. But the issues at hand do not only apply to the student press. Colleges across the country, if you've been watching the news, have been coming under fire about administrators refusing artists, musicians, or speakers that may bring the potential for controversy. A few examples of that. In June, 67 students at Vermont's Middlebury College received disciplinary action for disrupting a speech by a white nationalist. Last week, 9 students were arrested while protesting a conservative speaker at UC Berkeley. Now let me make myself clear that I'm in no way saying that we as Americans should be required to support the ideas that we disagree with. So, there are times that especially extremist groups are saying things that we should oppose, and we should oppose vigorously. But what we should support, and what the First Amendment tells us we have to support, is their right to express their beliefs. So you don't have to endorse what they have to say, but the First Amendment is designed to give them the right to say it. So protests on college campuses are happening weekly. Most of them are peaceful, but they are usually because administrators are either allowing or disallowing certain speakers because of their viewpoints. So the freedom of speech on one side is fighting to take away the freedom of speech on the other. It's gotten so widespread that a group called the Foundation for Individual Rights in Education, or FIRE, is actually compiling a list of speakers who have been disinvited or otherwise prohibited from speaking on college campuses. Most of those have actually been commencement speakers. Not surprisingly, in its recent State of the First Amendment report, the Newseum Institute revealed that 43.3% of their survey respondents believe that colleges should be able to ban controversial speakers, and I'm quoting, with histories of provoking extreme opposition with the purpose of shielding college students from scary ideas. And that's a direct quote. So my question that I would like for you to think about is, do you guys as college students need shielding from scary ideas? Do college students and should college students have the right to listen, speak, debate, research, and agree on controversial topics, difficult topics, scary topics? Do student newspaper journalists or student journalists in general have a right to report on their campuses, have an obligation to report on their campuses, even if doing so leads to an outcome that a university administration might not like? Those are the questions that deserve to be answered. And today, 25% of Americans feel that the First Amendment goes too far in protecting freedom of speech and freedom of expression. We see it on a daily basis on college campuses with students afraid to express their ideas, afraid to express their opinions, and student journalists dealing with that chilling effect of not being able or allowed to cover items of importance for the campus communities because of administrators denying their First Amendment rights. So I think this topic, the First Amendment in general, is perhaps more important now than it has been in recent memory.
Okay, I'm going to narrow the scope here to you as an individual and your phone. Defamation is not protected by the First Amendment, and defamation is pretty much trash talk, talk that defames. You've heard it as libel, but now there's a new term called twibel, which is tweeted libel. So, if it's not protected to say something bad about someone in a tweet, why aren't we all in jail? Or is it just me? All right, this is why. The burden of proof is on the defamed person, and they have to prove that what you wrote about them, what you tweeted, was false, and that it was indeed defamatory, and that it hurt them financially or hurt their reputation. And if the person you tweeted about is famous, They have to prove actual malice, that you set out on purpose to hurt them, and reckless disregard for the truth, which means when you wrote it, you had serious doubts about whether what you were writing was true or not. Then they have to prove that it wasn't in the public interest. It wasn't information people had to have in order to conduct themselves as citizens. And if they're a celebrity, they have to prove that it wasn't fair comment. So if you're famous, you're a performer, you're going to get some bad reviews. The law allows for that. So here's some scenarios. See if any of these sound familiar. You tweet something bad about somebody. You're probably okay. If you tweet it to a bunch of followers and you get a lot of retweets, you might be in trouble. If you tweet about a celebrity, you're probably okay. And if you tweet about a public official doing public official stuff, you're almost always okay. And why? Because celebrities and public officials have to prove so much more than a private citizen has to prove. Remember, they have to prove the regular stuff, that it's false, it's defamatory, they got hurt. Then they have to prove that you set out with malice, with reckless disregard for the truth, and it's not in the public interest or fair comment. So that's a pretty heavy burden of proof. So PR consultants, we tell our clients, don't sue. Don't sue for the obvious reasons. The suit keeps that story in the news. It keeps that trash talk alive. Also, if your movie was bad, you're kind of asking for it. And you almost always lose. Most defamation cases are lost. And your consultant and your attorney are charging you by the hour. This is expensive, and you'll probably lose, and your reputation will be even more damaged. And yet, they sued. Lindsay Lohan sued, of all people, sued Pitbull over a rap lyric, locked up like Lohan. I love it. Locked up like Lohan. Well, she lost her case, just like her PR consultant told her she would. She lost her case because it turns out that works of art are usually protected speech. But sometimes celebrities win. James Woods got twibbled. @AbeListed tweeted that Woods was a cocaine addict. Woods sued for $10 million, but got an out-of-court settlement, even though @AbeListed had died. Now, Woods then tweets, learn this, libel me, I'll sue you. If you die, I'll follow you to the bowels of hell. Get it? And then he deleted that tweet, but not before someone got his screen grab. Now, sometimes celebrities get sued for twibble. Courtney Love, never the soul of discretion. Courtney Love is the first to be sued over tweets, and she's paid out nearly $1 million so far. She tweeted that her stylist was a drug-dealing prostitute, and she didn't use those words. She lost that case. And she said her attorney was taking bribes, and of course, the attorney won that case. There's a long list of celebrities and politicians in defamation fights. Why? Because the First Amendment encourages, welcomes, and fosters open and robust debate for the greater good. With that in mind, keep your eye on James Woods. He's in another twibble battle with Amber Tamblyn, and that's going on right now. Okay, that's all I have.
Thank you for the presentations. Now, any questions from the audience? Got one back there.
Going back to your Twitter libel examples.
Yes.
How do you feel that applies to the recent Martin Shkreli case where he put a bounty on Hillary Clinton's hair?
I'm not sure that's libelous. it's probably actionable upon, under some other standard, do you think?
Y'all were talking right before the meeting, would that constitute a direct threat to a third party in that case, and therefore it wouldn't be protected speech?
I don't know, I would think that that's probably, in the light of what is today, considered opinion or considered parody or, you know, something that's not really taken serious. Now, if someone actually went and abused or physically attacked Hillary to get a hair strand, you know, that's a different story. But I guess you gotta see where it's coming from.
The actual Facebook post was that he would offer $5,000 to anybody who would go to see Hillary on her book tour and grab a strand of her hair. And so they said that it was actually threatening because it could have
Well,
been
if
carried
it's worded
out.
that way, yeah, it could be carried out. Except if you pay it, well, no. If you paid it, you get a special meeting with her and then you can pull the hair.
Well, okay, so a time, place, and manner restrictions. So the example that you gave, do you think it would be likely that if I want to protest against, and I'll use an example, just several years ago, there was a strike against UPS. And so there were strike people walking the picket line, if you will, in front of the UPS center in Gray. Obviously, the UPS people wouldn't have liked that. So if they had gone to the parish and said, look, can you do something about getting these people off of our property, even though they're on the neutral ground, how would that play into a time, place, and manner restriction? In other words, if the parish had given them permission to demonstrate on the other side of the parish, people would kind of miss the point.
Right, that's part of the factor that it has to be some reasonable alternative method of expression. If they tell you to go down to the southern part of Terrebonne Parish and protest, well, that's not a reasonable alternative. They do have the right to restrict the protest on their property. I remember as a result of a case that I was involved in, there was going to be a protest at my house. And nothing I can do about it. In fact, I'll be honest with you, if that's really what they want to do, that's what it's all about. I was a public official. If you disagreed with something I had decided on, you have the right to express not only to me but to the public your dissatisfaction. And one of the odd things about it was I happen to live along Highway 1. So if you looked at what you thought was my yard, it went all the way up to the highway. However, there was a right-of-way for the highway and for public utilities that those people could have been very close to my house, and I couldn't have said anything about it because they wouldn't have been on my private property. I'm kind of a far field from the question.
Well, and actually, along those same lines, there was a case out of Baton Rouge years ago where a family judge was being picketed in front of the courthouse by a spurned friend. And
Wasn't me.
the court said that he could, time, place, and manner, he could not be enjoined from walking in front of the courthouse because it was a public entity, but he could be enjoined because some of the language he was using in the signs was kind of crossing the line to threaten her, you know, again, and going someone as a direct threat. And, you know, and also prohibited him from being within so many feet because he had made some personal threats. But as far as the actual sign, you know, time, place, and manner. I guess one of the time, place, and manner I remember, because I actually had that question on my bar exam, is if you were in Tiger Stadium and they could stop you from carrying in a sign that said 3:16, referring to the biblical citation. Well, and we had to discuss the time, place, and manner. And the restriction, I think it would be reasonable in that case because you're trying to avoid bopping the guy behind you with your placard as you stand up. That's one of the reasons you can't bring in umbrellas, I guess, if you want to think about it. It's a safety. It's not restricting the speech that you were saying 3:16, but you're restricting the placard or the method because of the manner, because of the chance for a safety concern. And like Judge said, if they gave them an alternative, you know, you can walk in front of Tiger Stadium all you want before the game, and, you know, these guys who wear the song, you know, wearing their robes that have, you know, the end is coming and so forth and so on, that's all fine. But, you know, I agree you can restrict perhaps the facility into which the,
I think if they restricted them to walking inside Mike's cage, though, that would probably not pass constitutional muster.
Mike would probably see to that.
Dr. Thysell, if you could maybe talk for just a minute to give us kind of an historical perspective, because it is, as Nicki said, over the last several months, we've seen all these tensions on college campuses over groups either wanting to speak or not being allowed to speak. And you mentioned the Gitlow case, that was the early 20th century, so we have, you know, the growth of the socialist movement, and so there was a reaction to that. In the 50s and 60s, you had, you know, communism and the reactions to that. So is the phase that we're going through now part of just kind of an ongoing pattern of increased tensions?
No, I think that's, I'm not sure if I answered your question, but I don't think things have really changed all that much. You know, again, if you look at all the various First Amendment tests, clear and present danger doctrine, all they're basically doing is building on what eventually has been done. And I think the thing about what the Supreme Court is always trying to do is they're always trying to refine every test that comes before it and adopt it to present situations. And again, in terms of speech, what it shows is speech is not an absolute. That we were talking, the government does have the right to intervene if they can show it a just cause why they're doing that.
Last year, the Student Programming Association here at Nicholls wanted to bring a specific artist for Crawfish Day, and it was shot down by administration before it was ever brought in front of the students. Do you feel like that has something to do with shielding students from scary ideas without even them having a say in it?
Honestly, that was one of the topics on my mind when I made that comment about Nicholls students. I wasn't just referring to things that happened with the student newspaper. Yeah, I do, because if the reasoning is what I was told it was, that I don't know anything about the artist, but I was told that it was somewhat controversial, that their music was somewhat controversial, or maybe was used some profanity. I'm not quite sure what the exact reasons were, but that's what I heard. So I think that that's part of a growing trend on college campuses, that students aren't aware that they should have the right to speak out against that. So I do think it's part of this growing trend that we're seeing, where college administrators are making decisions for students based on what they think students should be able to hear or should be able to discuss, rather than what students want to hear and want to discuss. You know, several years ago, and the Nicholls Worth has done this a couple of times throughout the years, that they've decided to start running sex columns. And I can't tell you the number of phone calls that I got over the years from people saying, well, you can't let them do that. They shouldn't be able to do that. I don't like that. But the bottom line was, it was the student newspaper, and it was their decision what content they wanted to run, as long as they were not breaking any other laws. There was no defamation, there was no privacy issue, there was no obscenity issue. So I think that it's this idea of, how should I put this? I think that we are a nation today that gets offended very easily by things, and I think that in an effort to try to stop controversy on college campuses, administrators have gotten used to saying, well, we'll just stop it before it starts, and then that way we don't have to deal with it. Do I think it's right? No. Do I think students should be fighting back against it? Absolutely.
The best way to put it is something I read the other day: speech is free as long as it's mine.
Exactly. And I think that that's one of the things that we're seeing on college campuses. You know, students oftentimes don't realize that all those open meetings and open records laws that Mr. Plaisance was talking about, that all applies to public universities as well. So students who are on public university campuses should have the same First Amendment protections as any adult that's walking on the street, or any professional journalist from the Comet or the Courier or the Times-Picayune who want to go out, well, Times-Picayune, I'm dating myself since they don't really exist anymore, the Advocate, who wants to go and get public records, or, and anybody else who wants to have a certain type of speech, a conversation. Years ago, we had a protest on campus from Westboro Baptist Church. I don't know how much you guys know about them, but it was quite the ordeal. They walked around with some incredibly offensive signs, and the students on this campus handled it beautifully. So I think sometimes we underestimate the ability of college students to handle topics that they disagree with, or topics that the grown-ups in the room think we should shield them from.
Three of them. You stood up, you first.
For Dr. Martin with the 12, do you think certain celebrities abuse the First Amendment of the Constitution doing all this?
Oh, I don't think anybody abuses the First Amendment. I'm an absolutist, but did you have a certain case in mind?
Kind of going off of, with Trump, he wasn't in the case, but like what he did earlier in his presidential campaign, all his tweets, trying to get attention for it.
That is a special case, and I just read something recently about what you can do when the government defames you. But Times versus Sullivan, erroneous speech is inevitable and free debate, so probably okay. Will, I know you.
Yeah, I came in a little late, so I'm not sure if this was addressed, but last week or the week before, there was the ESPN commentator who called Donald Trump a white supremacist online on the show. She did issue an apology, and I know that companies' right to fire someone has nothing to do with the First Amendment, but Sarah Huckabee Sanders did say from the podium of a press briefing that that commentator should be fired. So what is the First Amendment stance on the executive branch or using that bully pulpit to try to influence decisions of private business?
But I think basically the president, you can say, Pat, anything you want about the president. I mean, because he is a public figure, and, and he has to show actual malice on your point, but that's so hard to do, it's practically impossible.
But if you work for some, just to take the opposite side, since lawyers like to argue. But if you work for someone and that's not necessarily their direct purpose of industry, I think she'd have a hard time if she was fired winning a lawsuit against her employer, because they're in the business of sports 24/7, the worldwide, whatever, it used to be ABC, the worldwide leader in sports, and kind of went off the track somewhat to make that comment. So she's got she's got a right to say it, they got a right to fire her. And I'm sure their contract addresses those type of things.
Right, but what I'm wondering is, I completely agree, it is completely up to ESPN if they would want to fire her. But is it okay or ethical or legal for the executive branch to call for the firing? Because they did call for the firing because Sarah Huckabee Sanders, the new press secretary, went out and said that this reporter should be fired because her comments were, they were not good comments. And is it okay for the president or someone who speaks on behalf of the president officially to call for a decision to be made in a private industry? If it's ESPN's decision, then it seems entirely fine, but
I would think
okay
that
for the president to influence that?
I would think that the president's representatives can say whatever they want. I mean, ESPN, they can't mandate that ESPN fires her, at least I wouldn't think, but these guys are far more the expert in that case than I am, but I would think that they have the right to call for whatever they want, I would think.
Yeah.
It's their opinion.
Yeah.
It's their opinion. I mean, he, 2 days ago tweeted something about the little guy that's kind of nuts in North Korea?
Rocket Man?
Yeah, we call him Rocket Man or
That's kinda
something.
nuts. A
Yeah.
little bit.
Well, I just call him kind of nuts in North Korea. It's, he's a public figure. So, Yeah, I think whatever the president's press secretary said, it may not be best, as they're saying, from a PR person's standpoint, wanting to say that. It just brings it to light and so forth and so on, but can they do it? Sure. And not to, just to answer yours real quick, I think some celebrities do on purpose to get involved in First Amendment lawsuits because it makes them, they want the publicity, even if it's bad, okay? There was a former governor of our state, I know for a fact, who told a reporter when the reporter was real young, put my name in the paper every day, and he said, well, it ain't always gonna be good about you. He said, that's not the point. The point is I need my name in the paper every day to make me, the people want me. So some public figures, they don't care, they know they're gonna get bad publicity, so they just rev it up so they can be more prominent, or think in their mind they're more prominent, because now people have talked about it, you know? We've talked about Lindsay Lohan, and we, you know, and all these other people that might be insignificant, you know, to some of us, and who cares, you know, but now they're part of a big First Amendment case, and, you know, so they could go into the law books, and it's gonna be taught in school, and they, you know, in perpetuity, we're gonna talk about Lindsay Lohan.
I think we have time for one other question, if anybody has one.
All right, so this has to do with the thing about the signs at the LSU game. I forgot what case it was. I was literally just doing something, taking notes on it for something for one of my classes. But there was a case where New Jersey had a state statute just banning the distribution of pamphlets because people might litter with them. And but the Supreme Court declared it unconstitutional because you can't ban something based on something that might happen. So would that mean the signs, I think banning the signs of the game would be kind of like that? Because they said someone might get hurt, but will they get hurt?
On the bar exam, they don't care which side you come down on, they just want me to argue both sides. Whether you can, well, you could base it on prior experience, you know, and I'm sure at some point in time in the past, it may have happened. I would think that's the basis for the umbrella policy, that, you know, or you're blocking someone's view of the game, you're obstructing my First Amendment right to see the ball game with your sign. You know, throwing something on the ground, I mean, that's perhaps is a, you know, it's a crime, but it may happen or may not happen.
Makes sense.
Yeah.
All right, well, thank you to our panelists for sharing today.